Hello, everyone, and welcome to KWB Wealth's Transitioning Your Legacy webinar. We appreciate you all for joining us online. Of course, with COVID, we wish that we could meet in person, but as we're still getting through that, we appreciate you still tuning in. Today, we have the dynamic duo, as we often call them here at KWB, Robert Bullock and Igor Nikachin, presenting to you about estate planning. Hopefully, they will answer all the questions that you have. And just for reference, this webinar is being recorded. After the webinar is over, you will receive an email with a survey to give us your feedback. We would really appreciate it. Give us, things that we can do better, things that you want to hear more about. Everything is appreciated. So please fill that out if you don't mind. And also in a week or so, you will receive another email with a link to the recording, just in case you have Wi-Fi issues, whatever the case may be. You miss out, it will be recorded. And if you saw, there are some poll questions. We appreciate you guys filling those out. Bob and Igor are going to touch on those at the end of the presentation. We ask that if you see below, you'll see a Q&A box. If you have questions during the presentation, use the Q&A box, type in your questions, and Bob and Igor will answer the poll questions as well as any questions you may ask during the presentation at the end with around a 10 to 15 minute Q&A session. So with that, I'm going to go ahead and give the baton over to Bob and Igor and let them give you a little bit about what we're doing today.
Wonderful. Thank you, Claire. A little bit about myself, Robert Bullock. I'm a wealth manager with KWB for 25 years, and I'm based out of the Monrovia, California branch office. And I'm actually celebrating my 30th anniversary this year in financial services.
And my name is Igor. I am not 30 years in the services industry. I'm just 4. So with that being said, we do hear a lot of questions on estate planning, financial planning, and hopefully this webinar will help answer some of those questions. And especially now, we believe that it's relevant because looking at some statistics, there's about 45 million American households that are going to transfer almost $70 trillion in wealth in the next 25 years. So, statistically, you're more likely to be impacted one way or another than not by what they call the greatest generational wealth transfer in history. And so again, you're probably likely to be affected by it.
Igor, that's a lot of money that's going to be passed on to the kids by mom and dad. And I always wonder, are mom and dad ready to pass it on? Are they organized? And are the kids ready to know what to do with the money they're going to get?
And that's a good question. Most people, we believe, are going to fall under one of these 3 categories. Or, there are people who are trying to decide whether or not they need a trust. And if they need it, what are the steps to making it, creating it? Other people are in the process of inheriting a trust. So they've already created one, maybe their parents did, and the kids are actually going to inherit it. So they want to know about the laws, the taxing of the accounts, and that kind of stuff, and how it works. And finally, the third group of people are people who already inherited those assets. Now they just may want to know how to grow them or what strategies to implement to have that legacy continue to grow. So those are, hopefully we have something for everyone. And with that being said, let's dive into the basics.
There you go.
What is the difference between a will and the trust? Because those are used interchangeably.
Yeah, and I think a lot of people are confused when they hear will and trust. And so I'll talk about this on the screen that you see in front of you. First, a will is a legal document, just like a trust. They both assign, if you will, a list of assets and who's supposed to get them. There's quite a difference when it comes to cost. A will is, you could write out your own will. They're called holographic wills, and they're legal in California. Or you can go into your office supply store and buy one. So they're really inexpensive. Compared to a trust, you typically will go through an estate attorney, and they can be expensive. Typical trust will run you $1,000 to $2,500, depending upon how complicated the family relationship is. But the problem with the will is it doesn't avoid probate. While a trust, the whole purpose of the trust is to avoid probate. And I summarize it by saying you really have 2 choices in life. You can either do nothing when it comes to estate planning or do a will, guaranteeing it's going to go through probate, or you can avoid probate by doing a trust.
And so what you mean, even though the upfront cost of a will may be cheaper, you still have to deal with those later costs of dealing, well, not you, but your beneficiaries are going to have to deal with the costs of probate. So it may seem like cheaper now, but in reality, it may be cheaper to plan. And we hear the word probate a lot. What's so bad about it, and why would we want to avoid it?
You always want to avoid it if you can, because at the worst possible time, obviously after mom and dad have died, one of the family members or the family members, all of them, will have to go through the legal process of typically hiring an estate attorney, going into court, listing what the assets that mom and dad had, the agreement between the family members as to who's going to inherit it. That judge will review those assets and the agreements that the family has made, and then the assets can pass. The problem today, it takes $5,000 to $10,000 to go through probate, and it takes an enormous amount of time because of COVID and the lack of employees. At least for LA County, it takes at least a year. That's a problem if you've got bills to pay and mortgages to pay, and you can't access that account.
And I think one of the things that prompted this webinar in the first place is a specific situation with a specific client. Do you want to elaborate more on that?
Yeah, the long-term client had established an IRA account and had listed the daughter as the beneficiary, which is what you're supposed to do. And so the minute the client died, the assets went to the beneficiary. But mom also had a non-retirement brokerage account and failed to either put it into trust or to put it a beneficiary called a TOD to that. And so in order to the only daughter to inherit it, she's got to go through the probate process. And there are bills to pay, and she's got to hire an attorney and pay the attorney. Thank God she has access to the IRA that she's the beneficiary on, because she's going to have to wait at least a year to be able to get that the non-retirement account.
Right, and we want to make sure you avoid those situations, because the more we educate you now, the more you can plan ahead of these things now, the better off you'll be. And so, Bob, all right, I'm convinced. I need a trust. What are the steps to actually creating one, and where should I start?
Well, there's a couple of steps. First, let's identify what type of trust. There's a variety of trusts, but for 95% of my clients, let's keep it simple. Let's do a revocable trust, otherwise known as a family trust. And what you first do is decide, really, you put a list down as to what assets you have and who gets them. So if there's a house that needs to be passed on, indicate as to whether the house is passed on, whether the house is sold, and the monies are divvied up. If grandmother has a rings, a specific item that want to go to a specific individual, it really needs to be listed, and that beneficiary is listed on that list. Once you've got the assets listed and the beneficiaries, next step, you got to make some decisions or allow other people to make some decisions, both while you're alive, power of attorneys, both for financial affairs and power of attorney for healthcare. How extensive can someone decide to keep you alive? And then after you pass, somebody's got to settle the estate. That's what the successor trustee is for. And if you got minor children, someone should be appointed to watch over themselves, and that's what the guardianship is for. So those are important as well as part of the trust package. Once you've got all that done, now it's time to see the attorney. And we've got a list of attorneys in the area that we can refer you to, unless you've got your own family attorney that you can use. And so that's really the first 4 steps, but you're really not done yet.
Yeah, so you may pay attention and notice that the attorney really doesn't come in until the last step. And so the purpose of that is to really prep you as best we can, or prep yourself the best you can prior to actually meeting the attorney, because attorneys are expensive. And as financial advisors, we're trying to do the best we can to help you talk about some of these things, brainstorm some of the questions that the attorney will ask you, so that when you do come to actually meet with them, you're prepared. It could be fast, efficient, and hopefully cheaper as a result of that. And so that goes for creating the trust. But there is one more process, one more step after you created the trust that is crucial: amending it or revisiting it. And Bob, do you want to give some examples?
Yeah. Amendments, the whole purpose of a revocable trust is sort of in the name. You can change your mind. That's what the amendments are for. And so, so you've done the package. I always tell people, tell somebody that where it's listed, or give copies away. But I would say about every 5 to 7 years, pull out that trust package, review it, make sure that it's what you want. And so You really haven't completed the process once you've created the trust. There are other times that you need to review it as well, and maybe you're going to make some changes.
And some of these could be, new assets that you may have received or accumulated since you may not have had when you started working. Some of those could be family dynamics and changes, and something that no one could really foresee is tax law and regulation changes. One common example that may actually apply to a lot of you is if you created a trust prior to 2011 or 2012, when they separated trusts to AB, when one spouse passed, that may no longer be necessary, as now the state limit is increased to, I think, 12 million per person, 24 million per household.
Right.
So unless you're dealing with those kind of figures, then you really have no need for those old types of trusts. So that could warrant a revisit or amendment of the trust as well.
And I would also add, people ask us a lot, how much does it cost for me to make an amendment? Is it as much as the trust? And the answer is no. Typically, the attorney will charge you 100 to 150 to 200 bucks in order to do an amendment.
I'm sure it depends on the situation.
Absolutely.
And so that is the first part of the trust presentation. It's really helping those people who haven't set a trust up or maybe haven't decided whether or not they need one. And hopefully we motivated you to avoid probate and actually create one. And the second segment of this webinar.
And I would add one other thing. Parents really do get themselves organized, do a trust, because they're not doing it for themselves. They're doing it for the kids.
Right. And the second segment of this is on the kids' end, actually inheriting the trust. So the parents set the trust up, they created it, and they have the assets, they pass them down, and people inheriting the trust typically have some questions. Most commonly, there are two types of assets that get inherited. There are real estate assets, and unless explicitly listed in the trust what you want done with that real estate, most of the time, not always, but most of the time, it's sold. And proceeds are divvied up between the beneficiaries. Other times it's rented out, or other times it could be bought out. One family member can buy out the other family member. So the more detailed instructions are in the trust, the less guessing the successor is going to have to do. And then the other types of assets are investment accounts. So the non-retirement accounts are easy. Once you inherit a non-retirement account, you get a step up in basis. So basically the value of all your stocks and everything in
all the capital gains go away.
Exactly. All the capital gains go away because it looks at the date of death as almost the cost basis, the entry point for those new beneficiaries. So those are kind of easy. We could talk about investment strategies for those beneficiaries and investing that money in a way that's appropriate for them. What is a little trickier and involves a little bit more monitoring is retirement accounts, specifically Roth IRAs and traditional IRAs. Inheriting those, you have to follow some rules and regulations. For example, if you're inheriting a traditional IRA from a non-spouse, so from your parents or something, you typically have 10 years to take that account entirely out and distribute it. Now you can do it all in the first year. You can do it all in the last year. You could do it little by little every year until the account is depleted. The IRS really doesn't care. All they want is their tax monies. So planning and looking at, favorable tax years for those beneficiaries is another step in the planning process that we can hopefully assist.
So maybe coming up with a distribution strategy, depending upon what their taxes and what their needs are.
Exactly. Absolutely.
Well, good. That helps with the taxes.
And some of the other questions we get a lot, hopefully we'll answer with this slide. And just in general, give some best practices, because we get these questions a lot, and hopefully some of these will help you out. And so, Bob, what is something that individuals should do as soon as they find out that the parents have died?
Yeah. First thing, nothing really happens in settling an estate until you obtain some death certificates. And I would suggest, because every financial institution has their own process, and they're typically going to ask for a death certificate, get a couple of them. Get 5 to 10 of them, at least to start. The problem these days is they're issued by the county. You can normally get them through the funeral home, but they're taking weeks for the county to be able to issue them. Once again, because the lack of employees and the COVID effects.
It's not months.
Yeah, get quite a few.
It's always better to have more of them than less.
Yeah.
And so another thing that we strongly suggest you do is, again, you created the trust, great. And now you want to make sure your beneficiaries actually know what the trust is, if they need to pull it up and look at the instructions and whatnot. And so we always recommend you have that discussion with your beneficiaries, kids, whoever, successor trustees. Make sure they know the passwords, make sure they know where the trust is and they're organized. So if something happened to you tomorrow, they could essentially continue to make decisions and act on your behalf then. And so something else?
I would actually add to that, if there's safe deposit box keys.
Yeah.
Do the beneficiaries or does the successor trustee know where they are?
Right.
Because otherwise it's expensive to drill into that safe deposit box or to find it.
And again, you're dealing with this at the worst possible time. So the easier you can make the process, the further it's going to go. And another thing we always say is bring a copy of your trust to KWB or bring the trust and we'll make a copy for you. That way, if something happens, you can just let your beneficiaries know, look, go to KWB, they'll take care of you. They have the trust, they have the assets, and they can help you. So we can most definitely do that for you as well. And
I do the last one.
it's the easiest.
Yeah, if you could go back just one. There's a couple of things that you don't want to put into the trust. It's typically those things that you can add a beneficiary to, like retirement accounts, like 401ks, like IRAs, life insurance. If you name a beneficiary, the minute the person passes, the money goes straight to it. Sometimes you want to put IRAs into trust name, but typically you don't want to put them in trust name. Just make sure that you got listed beneficiaries on these type of accounts.
And again, that example of that one client who was fortunate because she was listed as the direct beneficiary on the IRA. So the mom passed and now she has to go through probate, but at least she has the funds to do so, the liquidity to do so. And she could wait a year dealing with this whole process and pay the attorney in the meantime,
Right.
Just because, again, she was listed the direct beneficiary. And other reasons you might want to consider listing direct beneficiaries, just easier. You don't have to file a tax return for the estate. That's one of the big things that no one wants to deal with. It's just an additional headache. And it gives you a little bit more flexibility in terms of deciding who takes what when, as opposed to the successor trustee. If you were to name the trust as the beneficiary, has to decide the best for all three of you. So when is the distribution going to be? If it's not the good tax year for you, well, that might not be avoidable.
There are reasons to name a trust, but for 95% of the clients, it's better, it's cleaner, it's faster to name the individual beneficiaries as opposed to the trust.
Right. And so that is about the second segment of actually inheriting the estate. And the third one and the final one that we want to make sure you focus on the most is really making sure the legacy you're trying to build and preserve lasts. So one of the things that we want to encourage you to do is try to have a conversation with your beneficiaries and gauge to see how they would answer some of these questions. Ask them what they would do if they inherited the family estate. And are your assumptions consistent with their answers, or are they significantly different? Are they going to use that money to buy a new car? Are they going to use that money to pay down high interest debt, student debt? Are they going to use it to supplement their retirement, the nest egg? Try to gauge and see what their plans for the money are, and that way they'll be better prepared.
Likewise, you could also express as to what you would like the kids to do with this inheritance. There may be some dreams of putting the grandkids through college or something like that. So it's a two-way street.
Right, absolutely. And another important thing to think about is just what would your beneficiaries do if they weren't receiving your estate? Are they hoping that it's going to be there, or is it just a cherry on top of their already built cake? So it's one of those things that you really want to make sure they're not relying on it too much and they're cultivating those financial habits and that financial wealth mindset that got you the assets that you accumulated over time, the behavior. And finally, just trying to see what your kids will do with the money. Are they going to invest it? How are they going to manage it? Are they going to sell everything and buy crypto? Hopefully not. So really have that conversation. We feel that families that do have that conversation are ultimately better prepared and more successful.
And I would say every time we do a financial review, whenever the client comes in and we're looking at the live well plan, And we can look at, this is the value of your estate 5 and 10 and 30 years down the road. I seriously doubt any of our clients have expressed to the kids, you know, you're going to inherit $30 million in 10 to 20 or 30 years from now. And I wonder, it would be useful if the kids knew some of that in order to both mentally and physically prepare for what are they going to do with this asset? How do they manage it? And so bring the kids in, if you will, and we can begin to educate them as to how they manage something like that. And likewise, bring in your successor trustee. We can begin to educate the successor trustee on their fiduciary responsibilities of settling your estate.
Right, and it's more also about the mindset, coming back to the legacy mindset that you want to leave. If they see these meetings, if they participate, if they see the power of compounding over time, then the decisions that they may make with the money when they receive it may be drastically different than just receiving it. So we're here to help develop that mindset and help them build the wealth we're passing on. So with that being said, you worked hard for your wealth. Let's make sure that legacy continues to last.
And let's make sure the kids know what to do with it.
Exactly. And with that, there were some poll questions. I think we had 2 questions.
So before we get into our poll questions, my name is Claire, by the way. I forgot to introduce myself at the beginning. We were just so ready to get into our webinar, of course. But thank you again to Bob and Igor. We had no doubt that you guys would absolutely kill it as usual, the dynamic duo that we often call them. But we want to again thank you guys for all coming. This webinar is being recorded. You will be receiving an email, just to reiterate, with a survey to get your feedback, and also with a recording in about a week or so. If you do have more questions that you don't want to ask right now, maybe especially with estate planning, sometimes it's very customizable, whatever your questions may be. So please, send us an email, call us, or as Bob and Igor already said, bring people in, bring your families in, and have that conversation. Give us a call at our office, and we'll be happy to set up a meeting. But for right now, I am going to log out, and I'm going to show our screen here so we can see the beautiful faces of Bob and Igor, and not mine right now. And we're going to touch on those poll questions. I will launch the results from that, and we'll get into our Q&A. So once again, thank you guys all for coming. And if you do have to go, feel free, but this is being recorded and you will be able to access all of this at some point. So with that, I will launch our poll questions.
Hey, everybody, this is Rachel. I'm going to be talking about the poll questions. So the first one, how many Americans die without a will or estate plan? About 25% of you, I guess 11% of you said 25% of people die without it. Majority of you said between 75 and 55%. And the correct answer is 55%, correct, Igor?
Yeah.
Yeah.
That's a good question. I'm just kidding. It was 55%. So it's good to see that most of you guys got that answer right. So more than half.
Yeah. Yeah, so that's actually a lot of money that's going to the state, right?
Yeah, and the attorneys love it because they're going to have to deal with it or help the family be able to pass that money on.
That makes the probate even longer. If there's more families inheriting more wealth and less people are prepared, then 2-3 years from now, it may not be inconceivable to go 2 years through the probate process and plus double that.
I will comment that where we've seen it as of recently, mostly it's happening with houses. So the house did not get put into the trust, and on the deed there was, sometime in California you can do like a quick deed to have a beneficiary listed, but that's not in all states. And so we've had a couple of clients that have had to go through probate just to get the house. Like the other assets at the IRA had the beneficiaries listed, but the house has been a big thing.
Yeah, but Rachel, I'll add to that. A lot of people will go through the effort of getting the trust package. And like you said, they don't take the effort to get the house out of mom and dad's name to be recorded into the trust name. And so that's a step that either the attorney or the couple or we can assist you with, of making sure that title on that house is actually re-recorded at the county into the trust name.
Oh, thanks, Bob. Okay, second question. Americans pay blank a year going through probate. This can be avoided with an estate plan. So it looks like most people said $1 billion. So I get, what's the answer, Igor?
2 billion.
2 billion. Okay. That's collectively. Wow, that's a lot of money.
Yeah.
Okay, so I'm going to go ahead and we have some questions that people have asked. If you have a living trust, is it better to hold an investment or bank account in a trust or as joint with beneficiaries, such as a TOD or a joint TOD, transfer on death?
So I could try to answer this one. So depending on the type of an account, if it's a non-retirement account, a brokerage account, a TOD, it typically is better just to have it in trust name. So register it under the trust and instead of the TOD, but the TOD would be the second best option probably, because at least you have beneficiaries. At least you're avoiding the probate step by listing direct beneficiaries in the account. However, if it's a retirement account, that's a little bit different. That's where we suggest, when possible, directly list beneficiaries. So maybe you want to log into your old or even current 401k providers and see what the beneficiaries are listed as. If any of them have changed, or if you have listed the trust before, now may be a good time to reconsider and list the beneficiaries directly.
Thanks, Igor. Is there any difference between leaving a trust to people or charities?
Yeah, there are. There are specific rules that have been updated in the last 2 years. There were some major changes for the estate laws in 2020. And there's a 10-year rule if you're it depends whether it's a real human or whether it's a non-human like a charity as to the time frame as to when that money needs to go. And so there are some specific rules depending upon whether the money is being gifted to an individual versus a charity, making it quite complicated.
Yeah, so if that is something that you're wanting to do with your trust and your estate, let's just make sure we talk about it with you, and then or get you in touch with an attorney to make sure it's set up correctly for you.
Right.
Okay, and then upon death of both trustees in a revocable trust, that trust becomes irrevocable. Is an EIN then required?
Typically, usually in settling the estate, you typically will get an EIN number. It's cleaner. And for the successor trustee, typically establishing an estate account and I have check writing ability on that. It has a record of the money that's come in. If the house has to be sold, those proceeds are put into that account. Then you can distribute it. So there's a cleaner record as to what the successor is doing in case there's a question from the beneficiaries. So I would just suggest establish an estate account that has its own EIN number.
And that will be useful for filing taxes if you're planning on having that estate last for several years or longer time frame.
Yeah, so and just to be clear, so yes, once both trustees have passed, then we establish, you apply for a tax ID number for the trust, and then there moving forward, you would be filing a tax return under that trust, under that tax ID number for that trust.
For as long as it takes to settle that estate.
Takes as long as it. Okay, and then the next question. So this client has some funds with us in the revocable trust name. How does the successor trustee access the funds?
It all starts with the death certificate. So once the client has passed and the successor trustee gets in contact with us, we can help meet with them initially, but we can't really do any paperwork kind of stuff. We can help prepare them. We can help point them in the right direction, have everything set, but we can't actually change any ownership or anything like that, or give any authority until the death certificate is come in. And each financial institution will actually require one. That's why we suggest getting several copies.
And before anything is done, I would tell the successor trustee, pull out that trust and begin to review what the wishes are. And so when you're given that authority, you know what to do and how to act. So I would use the time to prepare yourself to review what the wishes are as listed in the trust, so you can do something when you have the authority to do something.
Or even easier, prep ahead of time while you can't talk to that client.
And if the client's been working with us, usually we will work with the successor trustee to help distribute the estate according to what the trust states. And then also, because we've had the relationship with you as the client, we can guide the trustee, the successor trustee, to do his fiduciary duty make sure that they are meeting what we know as you wanted as the client. So, we have to do what the trustee tells us to do, but we also will, help the successor trustee on your behalf. If you are married but have separate assets, do you need separate trusts?
Typically, I would say yes. It depends whether those assets were obtained before marriage, whether they were obtained during marriage but kept separately. And so you can keep them separate, and therefore you need your own trust to identify as to what happens after your passing. But yes, I would say I would do a trust, but it depends upon how you obtain those assets and when you obtain them.
Does it matter what type of state you're in, community versus?
It does. Obviously, we've got clients all over, and each state has their own unique rules. And some states are community property states, and some aren't. And so it's difficult sometimes to answer specific questions depending upon your locality.
Can you touch on what's the difference between a community property state and non-community property state?
In general, a community property state means that once you're married, all assets obtained are shared. There's a 50% interest in whatever that property is. Unlike, and I forget how many community property states there are.
I think there's 9.
Okay.
California is one.
California is one. So it's really all assets obtained during marriage are shared equally by the married party.
And that's why you have to list the spouse as a primary beneficiary on your 401k and your IRA and all that kind of stuff. And you can't avoid it. You just have to have some signatures, notarized signatures. But California is trying to make it so that, the general path is that you list your spouse as the primary and they're the beneficiary on all of that.
Okay, and the next question, does it make sense to add a name versus a beneficiary to bank accounts? So you kind of touched on this, Igor, but maybe a little bit more.
So bank accounts, it makes sense, again, if you want to if it's a substantial amount, it makes sense to have it in a trust name. Most of the time, that's what people do. They just have it registered under, again, the trust, because you can't really list specific beneficiaries like you can on an investment account under a bank. So since that instruction of passing on assets isn't there, it's better to be safe and just list it as the trust.
I would agree with that. If it's a substantial amount, I'd put it into the trust name. The alternative is some institutions like credit unions allow pay on death, PODs, which is like adding a beneficiary to savings and checking. But I'm always cautious when a client says, I'm adding my daughter to my checking account in case something happens to me. I understand what the intent is, but there's always a risk. You're giving the family member 100% control over this asset, and they could take it and you can't stop them. So I'd rather add a beneficiary if you can on that local bank or savings account by doing, once again, a TOD or a pay on death. But if it's a substantial amount, I would put that savings and checking out in the trust name.
How does that help as well in a situation where maybe the trustee is incompetent and can't make, they can't pay their bills? How does having the bank account listed as a trust help in a situation like that?
That's an easy one, because typically when you contract with an attorney to establish the trust paperwork, included in that trust is also power of attorneys. I highlighted that you need to list someone who can make decisions for you while you're alive if you're unable to. So if you're incapacitated, either because you're losing your mind or you're in a horrible accident, well, someone needs to be able to pay your bills and to pay the mortgage and pay the healthcare workers that are assisting you. And so by having those durable power of attorney documents enclosed within the trust handles that type of situation.
Also, Bob, one question that has been asked a lot is what is considered a substantial amount exactly?
Yeah, I think it's subjective to each individual as to whether 25,000 or 100,000 is considered a large amount. And so personally, I would think if it's $50,000 or more in a savings account or checking account, it really should be included within the trust.
So I have another question for you guys. If I'm concerned that my children won't manage my assets responsibly when I pass, who should I appoint as a trustee?
Try to talk to them, try to educate them, try to see what steps you can take to maybe get them on the same page as you. Maybe that would be a good exercise for them to actually grow into that role as opposed to just get that role and go from there. So I would always suggest that if you do want your kids to inherit the estate, talk to them, show them why you put away money into a 401k, show them why you kept it invested, and hopefully they'll see the fruits of your labor, essentially. So that would be the first course of action. But if that's not the case, then depending on how old the kids are, if they're still minors, then the guardianship, that's what it's for. It's kind of to help have that another figure and kind of provide guidance for those kids during that time.
And I would add to that once again, if it's a substantial estate, you can hire a trustee that can manage those assets. There's fees associated with that, so the estate has to be large enough to justify that. And usually, if we're looking at hiring a professional trustee to manage those assets on behalf of the kids or the beneficiaries, the estate needs to be a couple of $1 million in order to justify that.
It also lists instructions for what you would like to happen with some of those funds, or when, or pay out in certain time intervals. Like, for example, X amount will be available at this age and this age. So the trust is really there, and it will add complexity to it, making it a little bit more expensive, but you can give some of those specific instructions and highlight them in the trust as well.
And Rachel, I would add that sort of like what I highlighted when I was reviewing the wills and the trust. The parents have two choices in life. They can either do nothing or do a will, and at least the money will go where it needs to, but it's got to go through the expense and time of probate. Or you can help the kids at the worst possible time is when you pass by doing a trust and answering those questions as to this is what I've got, this is who's going to get them, this is when they get them, and all that can be incorporated within the trust with a discussion with the estate attorney.
And
then helping the kids get into that role, that's why we always encourage people to bring the kids, successor trustees, family members, just at least for education, if anything.
If you have a trust, do you need a will?
Yes, because one of the things that you will have within the trust is what's called a pour-over will, and sort of is saying, okay, if I have a trust and I've put all my assets in the trust, but 5 years from now I've purchased something and I never really put it into the trust, it can capture that asset and pour it into the trust, so you don't have to go through probate.
But ideally, just revisit that trust. That's why we encouraged you to, when some new assets come up, when a change happens in family dynamics or laws, just revisit that trust occasionally. Make sure it's still valid.
Okay, and then another question just came in. If the home is sold by the trustees, is the equity taxable?
But it's taxable to the estate. It's just like if mom and dad sold the house. And if they have, there's a $500,000 exclusion on gain. And so if somebody's got to figure out what the cost basis is and what they sold it for, and the first $500,000 for a couple is tax-free. But if there is a profit above that $500,000, the estate's going to be responsible for that tax. Sometimes we get the question, if the kids, do the kids pay the taxes on as a beneficiary? And that's unusual that they would. There's typically not a tax by inheriting money. If there's a tax, it's the estate that typically will pay the tax.
But with the house, wouldn't they get the step up in basis?
They would.
So I think that was kind of the question. So if you get the step up in basis, so when someone passes and then there's the property, wouldn't it be in their best interest to get the house appraised pretty much immediately? So then we have the value of the house on the date of death, and that's going to help you when you go to sell it, because you'll have that new basis. So if they bought it at 100, well, today when they pass, it's at $1 million. The beneficiaries won't have to pay the tax on the 900,000 because they got that step up.
Before that 1 million essentially.
But anything, if you wait a year or two to sell it, then yes, you will be responsible if there is a gain. Correct?
Right.
Okay. And then one other question, and then we'll wrap it up here because we're getting close to time.
Right.
During the presentation, you said that you wouldn't want to list you likely don't want to list the trust as beneficiaries for an IRA or 401k, but there might be times where you'd want to. So what would be an example of a time where you'd want to list the trust as a beneficiary on the IRA?
If it usually comes down to trying to keep assets to be put into that individual's name. Maybe it's a special needs situation, and so you don't want to give them a ton of assets. You want to keep those assets still in trust name and not give them to them individually, because they could lose maybe those benefits that they're receiving from the state or from the feds. It may be a situation that individual doesn't know how to manage it, or the minute they get any money, they're going to blow it. And so you can use the trust to divvy up those type of assets, to manage those assets for a period of time in order to assist that child. And so there are reasons that you want to list the trust. They're few and far between, but it's having the discussion, what the concerns are, in order to decide as to what's appropriate. But for most of us, it's best to list retirement accounts as beneficiaries, and for non-retirement accounts to list them in the trust, so that those assets can pass. But naming a trust, there are reasons to do it, and there are specific causes to do it, but they're few and far between. Usually it's special needs, or you're trying to keep money from a spendthrift in that regard.
Yeah, and if there's less beneficiaries, it makes the successor trustee's job a little bit easier in terms of planning those distributions and really making sure they have an approach that fits all people involved. So, if there's just one person inheriting it, maybe it'd be a little easier for that successor trustee to actually go ahead and implement that strategy. So it gets more complex. There's more of a reason to list direct beneficiaries individually on your retirement 401k IRA accounts, as opposed to listing it in trust name.
Great.
But Rachel, I'll also add, it goes back to the question. I'm glad we're getting all these questions. That shows there's interest, but recognize half the public dies without doing anything.
Mm-hmm. Yeah. Crazy. Well, thanks you guys. We really appreciate your wisdom and the presentation today. And thank you everybody for attending. If you have questions that come up later today or tomorrow, what have you, please feel free to shoot us an email. We're happy to answer them for you. And like Claire mentioned, we're going to follow up with a little survey, if you don't mind filling it out, just to get some feedback. We can make sure that we are providing the content that you guys want to see and answering the questions that you want answered. So thank you again. Thank you, Bob and Igor. That was great. And we will see you all soon. Have a great Wednesday. Thanks, Claire.